All right. Hi, this is Kurt Verone,
And Brad Pinsky.
and we're here for another edition of File Law Roundup for September 15th of 2025. Brad, go ahead.
And we are going to be speaking about this next one for the next number of years. You gathered really well, by the way, gathered a whole bunch of very recent, and it will continue certainly through the lawsuits, I'm sure, very recent cases, all involving around social media posts made by fire or EMS personnel, government employees, and I think all these cases,
Mhm.
about the Charlie Kirk assassination prompt. So before we get into these, for everybody, let's review Pickering. Because this is going to be a First Amendment issue. And the basic Pickering rule is that we say it in the negative or the positive. Employees generally have no constitutionally protected right to speak as employees on matters. On the other hand, when you're speaking as a private citizen and not as an employee, which is always a question, um, and you're speaking on a matter of public concern, then without some small and I don't want to say rare, but uncommon exceptions, which are going to be relevant here, then you have the right to do so. And against that, we covered, I don't know whether it's 6 months or a year ago, but we covered a case where somebody was making very racist remarks,
Mhm.
and the court held that is not. Even though you're speaking as a private citizen, it could be attributed to you as a department, right? And that's not the culture the department wants to create. So and the court upheld the termination of that person, saying no violation of your First Amendment rights. So now let me read you some of the comments that people have been making from all over the place. And it's not where they're being made. To me, it's the comments they make that are important.
Right.
So we could do hours on this alone, right? I mean,
Yeah.
so
Absolutely.
comment one, I think he should be forced to carry that bullet in his body. The bullet has a right to be there because it's a gift from God. Now, you look at that. Is that something a firefighter should be saying? Maybe not. But on the other hand, people don't like this guy. Next one, wish the guy was a better shot. Another one, it was a red box with the caption, just got my limited edition Charlie Kirk Labubu. I don't even know what that means.
I don't, I'm not following it either, but I
Okay.
think my wife was saying it's some sort of a doll. So
Okay.
I don't know.
And then two more. Let's see. Good riddance, thoughts and prayers to the other guy. And then finally, out of Ohio, Cleveland, the world is a better place now that he's gone. It's interesting. These are all opinions,
Right.
right, from people who hate the guy.
Mhm.
I'm not saying, but on the other hand, should firefighters be promoting violence? And is
Well,
that,
I
are we
think
going to promote political violence,
yeah,
basically?
from our perspective, we got to approach it from an attorney's perspective. We got to approach it very clinically, and we apply the Pickering balancing test. And the balancing part of it, you kind of mentioned the first part of it, which is you got to do it as a private citizen, which I think all of these did. We won't know for sure until like the one of the things the investigation needs to look at is what did their Facebook page look like? Did
Right.
it look like something that was an awful lot like
Well, did it
our
look like
department?
this,
Yeah.
right, behind me?
Yeah, okay, so that you're representing yourself as a spokesperson for the organization, but probably not. And I think you give them the benefit of the doubt on that one. Then is it a matter of public concern? And when I lecture on this, I say disagree or disagree with what the person said. Does it go to a matter that is of public interest, or is it strictly a matter of personal, petty, or private grievance? And this is clearly a matter of public concern. So they've got First Amendment protection keyed up. Now, the other part is, does the firefighters' right to say what they said outweigh the fire department's interest in limiting what they can say? And that's where it becomes very difficult to balance. You can, and it shouldn't be this way. Unfortunately, though, the way it is, the reality is the judge's political persuasion can cause a case to go one way or the other. We see conservative judges. I can see conservative judges saying the fire department outweighs, the firefighters' rights. I can see a liberal judge, progressive judge going the opposite way, which is not what it should be.
Right.
But unfortunately, that's where we're at. Now, there's a few carve-outs that kind of fit in here and that courts have said cause a case to go one way or the other. And one of which is when you threaten violence or harm, or you encourage others to commit violence or harm, then that weighs more in favor of the fire department limiting the speech. Okay. Another one is where you either threaten to or you encourage others to withhold public services from certain groups of people. So I don't think so much the second part of that is, but I think the first one is right there in terms of, are they encouraging others to commit this type of behavior? Now, there is the other part of it, which has to do with can by saying this you cause disruption to the fire department's mission? Okay, the mission and function of the department, and that can happen two ways: with the public losing trust in the organization to deliver services to everyone, not just to people who align with you politically.
Right.
The other is causing disharmony in the workplace. And I think it's got to be ramped up a little higher for that disharmony in the workplace. But in terms of the public and the public losing confidence in, firefighters who are saying these kinds of things, it's problematic. But we won't know until the investigations are complete. We can speculate, but the investigations have got to be conducted, and there's a lot between where we are now and where it needs to be before outcomes are really on the
Yeah, and
table.
look, I'll give because I'm sure people are wondering, my personal view is they're all protected. I think all of those comments are opinion. I think they're based, it's not like we're going after the black community or the Muslim community, or right. We're not going after a community. We're going after a person who had, people can't even agree what views he had. I watched so much on this guy.
Well, people don't listen to him. That's the problem. People don't
Right,
listen to what he's saying, and they just say, "Oh, he's a Trump supporter, therefore he's a Nazi. He's a,
right,
he's
right.
a fascist and all that." And they don't listen to what he's saying.
Right. I think it'd be very different if somebody got in there, if his house was firebombed, arson, right? I think it'd be very different for the First Amendment issue if people were commenting on the arson, like, oh, glad they burned down his house type thing. That clearly would never comport with being in the fire department. But saying, I'm glad the guy's not around, which is nothing anyone should ever say, right?
Yeah.
But I don't know. I think it's all protected. You're entitled to say, I'm glad the guy's not around anymore.
Let me put it this way. I don't think it's as clear as some of the other cases that we've had, but
Agreed.
at the end of the day, there's a lot of factual things that have to be discussed. What's happened, I can tell you, there's a case out of Boston, really interesting case, where a firefighter was accused of saying one thing, and the investigation concluded that that was protected speech. We're not going to discipline you for that. But while we were doing the investigation, we found all these other things that you said. And we're not,
Oops.
now we weren't looking for it, but now that we found it,
Yep. You open the
you're going to be
box.
terminated because of all these other things. And the other things were way worse
Right.
than what was originally put out there. So, you kind of open Pandora's box there.
Yep. All right. Let's go to Durham.
Yeah.
And here we have, this is interesting. And I'm going to, the facts are long. I'm going to kind of
Yeah.
shrink them a little bit.
I
But
apologize. I did my best to kind of shorten these. Several of these this week are lengthy fact patterns, but
yeah, but to understand it, you really, right? I couldn't summarize it if you didn't have the whole thing. You got to understand it, and it makes sense. In any event, so we have a federal judge here has denied the town of Durham's motion for summary judgment, which is they said, listen, there's no questions of fact, there's only law. And the judge disagrees. The case, which will now continue to go on because the town tried to get rid of it on a motion, which is something I always try. But it's filed by a former firefighter who claims he was terminated in violation of the Americans with Disabilities Act for, as well as the Rehab Act, which really doesn't come into play, and New Hampshire law. And he says he had PTSD. And here's really what it was. So him and another fire officer, I'm guessing, in the fire department became friendly. The plaintiff shared that he has PTSD. It's brought on and aggravated certain things. They had a chief who neither of them apparently didn't like at the time. So this guy, the plaintiff, leaves the department, but had, a number of conversations about his PTSD and what triggers it with this
so,
guy,
Brad, before
Emmanuel.
we go much further, let me
Yeah.
just say, Chief Emmanuel's a friend of mine.
Oh, okay, good.
Okay.
So
So
I
I
mean,
just, I
yeah.
do want to, so.
Right. So, again, these are, and there's no factual determination yet,
Right.
right? This is a motion being denied. And on a motion for summary judgment, the party, the non-moving party, in this case, the plaintiff,
Mhm.
right, who the person who didn't ask for summary judgment, who's kind of defending it, they're entitled to all their facts being assumed as true for the purposes of the motion, right,
Right.
on the defense side. So that's why summary judgment's so hard. You give every favor to the non-moving party
Mhm.
in any event. So the plaintiff leaves the department, says he couldn't get along with the chief, kept triggering his PTSD. And then Emmanuel, who was getting along with, Chief Emmanuel, becomes chief of that department now.
Mhm.
So the guy returns.
Mhm.
Unfortunately, depending whose side you take, you don't know.
Mhm.
If it's Chief Emmanuel saying that this guy Powers, the plaintiff, is being disruptive, is causing some problems in the organization, not following some orders. So, and the plaintiff says, no, you're not listening to me, etc. And, we need to communicate better. So we need to meet to communicate better. In any event, what happens is Emmanuel, and I think their HR department or so, but they propose a performance improvement plan, which, by the way, is a great way to try to solve problems because it looks like you're trying, right? You're not jumping right to some discriminatory attempt, which someone will accuse you of. You're trying to say, we want to make you better. So here's what you need to do to make you better. Unfortunately, Powers the plaintiff was not overly cooperative with that, it's alleged, right? And ultimately, he was terminated. And for not cooperating and also, but this is the interesting part because this is really where the holding gets to. So
Mhm.
the interesting part is that at this meeting, Powers, the plaintiff, is claiming that Emmanuel, because of their conversations before and their walks, not only knew of his disability, of PTSD, but knew what triggered the disability. And the court comes out ultimately and says, listen, this meeting you had where he got, Powers got very upset, all that, it is possible that a jury could find
Mhm.
that you knew his triggers and you intentionally triggered him, causing us problems, which is both not only discriminating, but actually retaliating.
Mhm.
And so that's, they say, is a question of fact for a jury to determine whether or not, this case should continue. So it's going to a jury. The case is going to continue on that question. Did he cause the triggering?
Yeah, I think that's the key thing to understand that the court is not saying that the chief engaged in that behavior, but just saying that there's a factual question that needs to be determined as to whether or not the chief, behaved in a way that was either retaliatory or intentionally triggered. But the court is not saying he did it, just saying that it's got to go to a jury on that. So as I read it, and again, I obviously have a bias in favor of people that I respect and I know and that I trust their judgment. The thing that stood out to me is that we've got a plaintiff that is the chief's no good, the chief's no good, the chief's no good. Yeah, yeah, yeah. Okay. And now there's a new chief, and guess what? The pattern is the same. Okay, the Chiefs no good, the Chiefs no good, the Chiefs no good. And we see that over and over again. I'm not talking about whether or not it's true or false in this case, but we see that pattern. And whenever personally now, whenever I see somebody saying, I got a problem with this guy, I got a problem with this guy, I got a problem, they're no good, they're no good, they're no good, and then they move on to the next guy. They're no good. They're no good. They're no good. You start to wonder whether or not the two chiefs are actually the problem, or whether the common denominator is actually the problem. That's one of the things when I come into a case, and I'm not in any way involved in this case, but uh, I do. It causes me to pause when I see somebody who has problems with multiple people, and whether or not there's more than meets the eye there.
Yep, agreed. Okay, so this next one is yours. This is to me so simple on one hand for the holding, yet so complicated in its facts.
Yeah, and it gets to one of the reasons why FLSA cases become so complicated. Very often, fire departments have not taken the time to fully delineate what all of the parameters that go into someone's hourly rate is, and if you haven't clearly established what someone's hourly rate is, then when you go to pay them overtime, there's going to be a problem. And it's so important to clearly state that. So what we have is a fire department that they had a rather unusual work period. Now, for most people, you work on a 7-day work week, and your overtime is calculated on your work week. For fire departments and some police departments, they're entitled to establish a thing called a work period, which is longer than 7 days. It could be 7 days, but often it can go as long as 28 days. This particular department had a 19-day work period. Okay, so that's sort of issue number one, which it's kind of unusual. But the work period, the only relevance to the work period is that is the period of time during which we count the hours worked to determine overtime hours. Okay, and the magic number there for that is, what is it? 144. No, is that it? No, I forget what it is.
Thought that's what
You
they
see
said.
it? Do you see it in there? A 106? No, it's not one. What
No,
the
no,
heck
I
is it?
thought they went to the longer one. They did
Okay, well, whatever.
144.
Let's
19
just
days, 144 is what they had.
yeah, no, 144 is what some of them work. Um, I'll get the number, okay?
Okay.
But bottom line is they're working a 19-day work period, but they have a 14-day pay period. Okay, now pay period is different than a work period. Work period is the hours that or the days that you work to count overtime. Pay period is how frequently you get paid. And you don't have to get the overtime hours during a pay period as long as it's based on the work period. And it gets a little bit complicated if you're not following along there. But bottom line is they had a 14-day work period, and the department, and I get phone calls every day on this issue. Okay, they went with a new payroll system, and the payroll system does the calculations a little bit differently. But in this case, on the member's pay stub, it said 80 hours. Now, they didn't work 80 hours. Depending on the rotations, some of their rotations, they worked 144 hours. Some of them, they worked, what did they worked, I'm sorry, they worked either 96 or 120 hours. And so there was a rotation there. And the bottom line is the firefighters wanted their hourly calculation based on their 2-week period divided by 80 instead of based on the number of hours, 106 hours. I think 106 is the magic number. There it is. 106 hours is the magic number. And the fire department, the pay stub said 80 hours, but the math worked out to 106 hours, which is what the FLSA requires. So there was a lot of problems. The firefighters complained, numerous complaints apparently. The city ended up changing their whole process, and they went to a 28-day work period, and which is what is permitted by the FLSA. And bottom line is the firefighters now claim that that was retaliation. Okay, that because they complained about the 80-hour calculation, that was retaliation, and the court said no. There's no evidence of that. There was a problem. The fire department fixed the problem. They switched to the 28-day work period, and in order for there to be retaliation, there has to be an adverse action or adverse impact that they sustained. And, the court concluded that they really couldn't show that they suffered an adverse action or adverse employment action. So as a result, both their FLSA claims, there was no FLSA violation. The department had been doing it right. There was a screw up because of the payroll software, and there was no retaliation. There was no adverse employment action that they paid the firefighters consistent with the FLSA. So.
These are so complicated for people to understand, and it gets worse because if one of the two lawyers do not understand the FLSA well, one is right clearly because they understand it, and the other is like, oh, that just doesn't seem right. I mean, yeah,
Well,
right.
the
And the FLSA, you
FLSA,
just
the FLSA is fairly straightforward for most employees who work a 7-day work week and get
Right.
overtime after 40. But you start throwing in all the things with firefighters and the amount of overtime that most fire departments require firefighters to work, and all of the different ins and outs and different things that are unusual about our schedules. And this is, it's like a subset of a subset of a subset of problems. And unless you focus on the fire service aspects of the FLSA, it's easy even for attorneys that handle FLSA cases to kind of be confused by it all.
Yep.
And then you have two attorneys who are not firefighters and don't fully understand it, trying to argue it to a judge.
Makes it way worse. Who's never going to understand it.
Right.
Right.
This might be once in a career they deal with one of these cases. So,
Yeah, I will say I have as you know, a Fair Labor Standards Act case now pending in New York,
mhm.
on a unrelated issue, but same law. And that's my fear. You start wondering like, has this, because you have the option to file in state court or federal court. When you
Right.
file in federal court, all the judges have seen it. I file in state court for some reasons,
Mhm.
but you start wondering, is a state judge ever, are they really familiar with this? Sometimes that's good,
Well, if you
sometimes that's
could
not.
find if you could find a state court judge who at one time in their career was a firefighter.
Even better, right? If only you could choose your judges. Okay, well, let's go to Georgia. So we're the Georgia Higher Court. The Court of Appeals rules that part-time firefighters who regularly worked at least 40 hours per week were not improperly denied full-time employee benefits. Now, I read the trial court decision and it almost had a heart attack. But what happened here is they argued, right, saying, well, we should be getting all these benefits because even though we're part time, and I'm going to give some advice to everybody here, but even though we're part time, we're working full time hours, so we should get the full time benefits. And the initial court, the trial court, which is where I almost had the heart attack, rules, well, the policy manual could become a conflict or a contract between the employees, especially the part-time employees, and the employer. And I suppose it could if you had some really bad language in
It
there.
should. It should. I don't understand how they conclude that an employment relationship is not a contract. It has to be a contract.
The
It is.
policy manual being the contract.
Well, that may help clarify some of the terms, but the employment relationship is inherently a
Of course it is.
contract.
Of course it is. Now, I will say, when I do HR manuals, and I do one a month probably, and they're hundreds of pages long, these customized manuals. But right in the probably first 3 pages, first 4 pages, when I go through all the existing types of jobs, part-time EMT, full-time EMT, right? Per diem EMT, I have a line that says, regardless of how many hours you worked, the only way your job classification from per diem, part-time, full-time can be changed is in writing on our letterhead, and we tell you we've moved, and I put, it does not matter how many hours you worked. So I do that because of cases like this, but here the appeals court got it, I think they got it right. But whether the policy manual is kind of a contract or not is really up to the language in the policy manual. To me, I think that's a legal question, not a question of fact for a jury. But all the court rules here is two big things. One, some of your claims are just you filed too late, which was good, and that's easy. But the others, they said the city's policy manual was not a contract. And that's, but we don't, for our benefit, we don't know what it said in the policy manual. Was there
Right.
disclaimer language? Was
Well,
there,
I think about, I have a dog, right? If I put a sign on my dog and it says, I'm not a dog, I'm a cat, it's still a dog. Okay. And you can put your language in your policy manual, but if the policy manual that lays out all the terms of your employment is not at least evidence of what the
oh,
contract is, it's part of the contract. You can't say, oh yeah, well, we're putting all this in writing, but it really isn't contractual, right? I don't know.
yeah,
I'm perplexed. I'm also perplexed as to how the statute of limitations ran here, and I'm not sure I've got all of the issues because part of their issue was the statute of limitations claim. But if if somebody steals $1 from you every day, okay, and there's a 3 year statute of limitations. Okay. And in year five, you sue them. Okay. You should be able to go back at least the 3 years.
Right.
You can't say, well, they started stealing from you 6 years ago or 5 years ago, so therefore you can't go back after them at all, right?
True.
It
True.
should be how far you can go back. Same thing, if somebody punches you in the nose every day and you want to get them to stop, the fact that they started punching you in the nose before the statute of limitations, outside it shouldn't prohibit you. And that's one of the concerns I've got with this decision. But I will say, let's connect the Georgia decision and the Alabama decision that we just talked about. They both were pro-management, anti-employee. Okay,
Right.
if you want to just kind of
A
draw
lot
some,
of politics.
and we do see that some states are particularly difficult for employees to prevail in court. Okay, and then that in turn emboldens management to roll the dice and take some chances in the way that they treat some of their employees.
Right.
So,
Okay, well, the last one, I kind of went out in order. This is just
yep.
disturbing, again, as these always are. But we have a lawsuit filed against Los Angeles County Fire Department
Mhm.
and the CDCR, which is the Department of Corrections and Rehabilitation,
Mhm.
over an alleged childhood sexual abuse at a juvenile camp. And they claim that they don't name who the person is because they're a minor. So John Doe, I guess, is it John Doe or Jane Doe?
Well,
See,
no,
it
it's
was
John Doe, but they had a John Doe SC or CS, so I'm not sure what that
I
was
don't know.
indicative of, but I just used John Doe.
Okay, so whether it's a male or female, I don't know, but
Yep.
typically if they hide it for John male. And anyway, it claims that the child was subjected to a number of acts of childhood sexual assault, sexual abuse, sexual harassment, molestation, and that they were committed by other minors, but witnessed, or this is the disgusting part, encouraged by some staff members, including two. I have a hard time believing this, but supervisors, teachers, counselors, nurses, physicians, officers, custodians, and other staff members. Wait a minute.
Mhm.
How many people are allowed? I mean, I hope this isn't true because it's one thing when they say one person did something, but the fact that this was all witnessed by 7 or 8 or 10 or more people, that's the part
Well,
I'm having a hard time
and,
understanding and
and my
swallowing.
my reading of that is the person may not have a clear recollection of who remembered it, which is the reason why you have statute of limitations in the first place.
Yeah.
Okay, but I'll get
Except
off
in New
that
York, where
soapbox.
they allowed you to go to back 100 years
Well, that's the problem.
recently.
California did the same thing.
Same thing.
California
Same thing.
apparently is allowing them to go back, and now you have cloudy, recollections, and now you're going to have
You have no insurance.
supervisors, teachers, counselors, nurses, physicians, etc. now getting dragged into this, their
Right.
reputations, and we've got a plaintiff maybe that doesn't have clear recollections of who was where when the assaults allegedly took place.
Especially when some of these people might not even be alive. I mean, who
Right.
knows, right?
Right.
But yeah, so what California did, New York was way more harsh, but what California did, they amended the statute of limitations to make it 22 years after the plaintiff reaches the age of 18 at 40. New York did something like this, and as a result, I have 13 lawsuits still sitting in, they're in bankruptcy because they're against the Boy Scouts, but against fire companies
Mhm.
who had a program, right? An Explorer program or something. They just hosted it in their firehouse or somebody else hosted it in their firehouse and they allowed them to stay over in their firehouse, whatever. And now 60, 70 years later, you've got people, children making what may be true allegations, but
Yeah.
they're not defendable. In some of my cases, the people are dead, or, well, I don't remember exactly who it was. So this, the I don't like these at all because how are you supposed to defend it, right?
There's no winners here. I'm not trivializing what the victims went through. Okay, we're not, but just the reality of trying to understand what truthfully happened. Our memories are not all that good. Our recollections are not all that good, and especially after this length of time, people's recollections can be quite a bit different from what actually happened. And that's from the plaintiff's perspective, from the victim's perspective, never mind from, the defendant's
And how do you
perspective.
come up with alibis, right? Okay, fine. They're at a camp,
Yeah.
right?
Yeah.
They're at a camp.
Where were you on July 1st, 1974?
Wait a minute, at like 8 o'clock, because we know you were all allegedly at the same camp, right?
Yeah.
I'll give them that credit. So maybe they were all there, but I don't know. I was on the other end, or that was my day off, or prove it. Where are the records? It is unfair what these states do. You cannot prove it. And yet you're in a place like New York, California, where the juries are going to be very sympathetic to listening to this now 40, 50, 60-year-old person saying, oh, I'm positive what's happened to me. Yeah, they're positive as they remember it.
Let me throw this out. There's a PhD researcher. Her name is Elizabeth Loftus, Loftus, one of the premier forensic psychologists in the country. And her research has debunked a lot of the suppressed memory, the repressed memory concept, where people can be hypnotized or whatever and come up with recollections, accurate recollections. Her research has debunked that, but she did say a couple of things that are really, really important. One thing here is that when you have a memory, you usually, this broad statement here, but you usually store it as a good memory or a bad memory. And when something is stored as a bad memory, each time you go back and think about it, it gets worse. Okay, now think about that. Okay, and the good memories tend to get better, but the bad memories tend to get worse. And we had psychologists and psychiatrists and everything for decades that were telling people, you need to think about how it happened, go back and think about it, and somehow you're going to have a catharsis, and it's going to resolve that way. Her research is the exact opposite, that each time you go back and think about it, it gets worse and worse and worse.
Yeah,
Okay.
you're embellishing in your own mind.
Exactly. And so what can happen here with these well-intentioned lengthened statute of limitations is you can have these people this has been a bad memory for them. Each time they think about it, it gets worse and it gets worse and it gets worse. And I've got several good examples of that in testimony where people they went through something bad, and then each time they were interviewed about it, it got worse and worse and worse. And these are actual fire department cases where it got worse and worse and worse. So her research is on solid ground, and it's another reason why we really need to rethink lengthening these statute of limitations. And that's not to excuse any sort of sexual assault or molestation or pedophilia that is going on, but just the reality that it doesn't help the plaintiff in a case like this
Right.
if their recollections have been altered over the course of time.
And the unfortunate part is the states have ruled that the state courts have ruled that these are constitutional, that changing the statute of limitations, right?
Yeah.
So think of it. Let's assume it was a car accident, then we'll end, but assume it was a car accident, right? You get into a car accident, you're like, well, I have all these records on the car accident. I have videos, I have all this stuff, right? But now the statute of limitations expired, so I throw it away. 10 years later, you learned, oh, we've just changed the statute of limitation. Should have kept all that
Surprise,
stuff. And
surprise.
surprise. And right. And this is somehow constitutional. That is insane. This cannot be due process. You're told you only have to keep things for so long. It's like the IRS saying, well, I know we said you only had to keep your records for at most 6 years, but 20 years later, you better pull them out.
Yeah, I I agree. I agree. So, and it's unfortunate the LA County Fire Department kind of got wrapped up in this. They didn't fully explain how the fire department. I'm assuming it must have been a camp that had firefighters, or maybe they were, trying to teach the kids how to, maybe at some point in the future become a wildland firefighters or whatever it may be. But
No idea.
yeah,
Right.
unfortunate. So.
Well, that is it for this week.
All right, well, that'll wrap it up for another edition of Fire Law Roundup. If you've made it this far, okay, please help us out. Click like and share, and please subscribe. All of those things, every one of those things helps us with our algorithm, helps get the word out about what we're trying to do here. Brad and I love what we're doing, but, we need your support to keep doing it. So